Yes, happy Giving Tuesday, this December 20th, 2016. We are live here at the Intellectual Radio Station on iHeartRadio with the Consumer Legal Hour with Justina Winfrey, your community lobbyist here in Illinois, and Mr. John Carter. Mr. Carter.
Hello, and good evening to everyone, and it's great to be back. Happy holidays to all of you out there. I know that it's a busy time for me that are doing your Christmas shopping. It's also a time for despair for others that we're at holiday period. But either way, we wish you a great Tuesday, and we hope you had a great day. Tonight we're going to talk about credit and get an understanding of what credit is. It's something that, especially during this time of year, a lot of people wrestle with. Remember that when you see those bills that no payment until next year, during Christmas time or during Christmas weekend, about 2 weeks away. The next year is only about 2 weeks away. So don't get caught up in the crackdown when you hear those type of advertisements. They're not really deceptive, but for a mind that is not thinking ahead, you don't even have 30 days. So be wary of those kinds of things. So tonight, if you have a question, we encourage you to call in. The number will be given to you that you can call in if you have a question tonight. We'll give that number out earlier on rather than towards the end of the program. But tonight, we want to start off with the subject of understanding credit. And we're going to talk about what that is, what credit reporting business does, how banks rate you and everything else. And we're going to talk about the rights that you have and what can be removed from a credit report. What the law says is that a negative entry can stay on your credit report for up to 7 years. It doesn't say that it has to stay there for 7 years. What it does say is that it can stay there for up to 7 years, which means that it stays there until you effectively challenge the negative entry. And those are some of the things we're going to talk about. There are many consumers who have, at one time or another, been a victim of the subject of negative credit information. Fortunately, most of the time, the information that's passed on concerning the consumer isn't even accurate, which is a violation of the law. Most of you might know, or if you don't know, having a positive credit rating affects a lot of things in your life, in your day-to-day life, even a negative credit rating. It affects the rate you're going to pay for insurance. It affects what you're going to pay for the interest rate on your house, your car. It even affects what type of jobs you get. Because if you have a job, or if you apply for a job or get a job that pays more than $50,000 a year, then that employer is usually required to pull and base your employment eligibility on your credit report. So it's more than just applying for a line of credit and getting it. It's also really dictating what quality of life you're going to have overall. If you've had credit problems due to divorce, or bankruptcy, or loss of a job or income, a business failure, or any other financial crisis, the information that we're going to give you tonight is what you're going to need to get a fresh start. If you're among those consumers that have fallen victim to too much credit, you'll also find this information valuable, especially in the debt collection section, which we talked about last week. It's offered to those consumers who fully understand what went wrong the first time and want to start over again. So with that in mind, let's start with what the credit reporting business is. Many consumers are unaware of what the credit reporting bureau really is and how it works. It's important to know, above all, that the credit bureaus are not in business to serve you. I know that a lot of you have signed up with creditkarma.com and all these other things that you pull a credit report, but the credit bureaus and those reporting agencies are actually paid and kept in business by its clients, and those clients are your creditors. It is credit bureau's job to collect, store, and retrieve information regarding millions of consumers. It's quite a costly undertaking, and it's not, not to even mention all the problems that they have keeping all the information correct on all of those credit profiles. The business of selling information is a multi-billion-dollar industry in America. And more the United States is moving toward becoming a cashless society. So not only is credit important for financial transactions, but as we said, it's important for employing a person in virtually every bank, governmental agency, and business will purchase a credit report on you. So it's important that the information that's in that report about you is absolutely correct. The principal duty of the credit bureau is to assist the client, who is your creditor, in weeding out those persons who are considered a great risk due to negative credit. After all, what use would the credit bureau be if it only gave a positive credit report? So does that mean the credit bureaus are against you? No, not really, of course not. But what it does mean is that they're out for their own interests. And so what we're going to talk about tonight is how you can battle those giants and win. Credit reporting has been largely responsible for singling out and discriminating against ethnic minorities, as well as those in the lower socioeconomic classes. Since racial and gender discrimination is illegal, merchants who want to do business with those kind of folks have to devise some means to weed out the undesirable credit risk. This has to be done by the credit bureaus by flagging certain zip codes, which is called redlining, in areas of high credit risk. Those are usually done in lower income areas. Now, some years ago, there was a situation where there was a neighborhood that was redlined, and how they found out that it was redlined is because a store, let's say like Macy's, decided to send out some samples of some of the items that they had in the store. Believe it or not, what these folks will do is that they will look at redline zip codes, and while you may not get those samples to come shop the store at Macy's, if you lived in a different zip code, you probably did get them in a mailer that came in the mail or in your newspaper or whatever, or even to your email if you shop and do a lot of business online. There's hardly anywhere in America that a person can go and conduct business without the need at some point of a good credit card. Big ticket items such as automobiles and houses and even insurance rates have always required the need of a good credit rating and a good credit report. But you ask, well, how about to rent a car or to purchase a magazine by mail or even a hotel reservation? Notice that those industries push people to actually get credit cards because they don't want to rent to you unless you have a major credit card. Most rental car companies anymore won't accept most bank cards. Now, they really won't accept the green dot cards that you buy from Walmart, or a lot of those gift cards that you can reload. If you have a reloadable card that you put money on, you can rest assured that you're not going to rent a car with one of those. And in some cases, you can probably not even rent a hotel room with them. Some rental car places might rent you a car with a debit card, but you have to usually show a return trip. If you're traveling out of town, you have to show them your return trip. If not, you have to prove what your residential address is. And then they usually take a $200 to $300 deposit in addition to whatever the rental cost is going to be, and they put that on your card as an authorization. And then when you bring the car back, just fine, no problems at all. They'll still leave that authorization on for 4 or 5 business days before it actually drops off. So during all that time, because you used a debit card to rent a car or even a hotel room, you don't have access to your money. But the good news is that you have rights. And under the Fair Credit Reporting Act, consumers have very specific rights. One of the fundamental rights of that is to allow a consumer to obtain a copy of his or her credit report at no cost if the consumer was denied credit within the past 30 days. So you can go to creditkarma.com, and yes, they'll give you a copy of your free credit report, but you can also write one of the 3 major credit bureaus, TransUnion, CRW, or Equifax, and you can request a credit report even if you have not been turned down for credit. They have to give you 1 free report every 12 calendar months. So if you get a copy of that credit report, then you need to carefully look at it to determine whether or not all of the information in it is accurate. Because many times the information that's in your credit report, if someone has used or stolen your identity, may not be exactly correct. I pulled my credit report twice and found accounts that I didn't have. And at one point, there was a gentleman out of Kentucky that had gotten my information somehow. And he was using my credit report, or rather my credits, to open up 8 different accounts. And he used my social security number and my credit information to obtain a job in Kentucky. And he worked and used that information of mine for 8 years before I found out about it. And the only reason I found out about it was because he had committed a crime and the FBI had come after him and started an investigation to come after him. And of course, because he was using my information, guess whose door the FBI knocked on it? Mine. And I had never been to Kentucky. I had never worked at that place. But eventually we got it straightened out, but it took 3 years to fix it. So to protect and pull those credit reports to see what's on it is vitally important. The first credit report. Yes, go ahead.
No, I was just going to say very similar story. A few years back, I was actually in a situation with the IRS, and I waited and waited on the return check from your, yearly payment and that you make for your income tax payments. And someone had used my social security number and received my check. The IRS refused to give me their address and said that they would handle it. And about 6 months later, getting through that whole identity theft situation years later, it's still impacting my credit. And that happened about 2 years ago.
Yes, it can have a devastating effect if you go through identity theft. And right now, identity theft in America is $1 billion industry. It's $1 billion industry. San Diego Gas and Electric just the other day was having an issue because someone was calling, or these people were calling San Diego Gas and Electric customers. They are the ones who provide electrical services to the San Diego area. And some yo-yo was calling out people saying, hey, you need to pay your electric bill, and if you don't pay it, we're going to have to shut your power off because you missed the payment. Well, for the folks that fell for the trick, the next thing they told them, well, you need to go to the store and purchase a green dot card and put the amount of money that you owe on that green dot card, then call this number and give them that card information. Now, who in the world does that? I mean, really? Because have you ever paid your electric bill in the past with the green dot card? Probably not. So why in the world would you do it? But those are the kind of things that are going on, and people fall for it all the time. Under the Fair Credit Reporting Act, every challenge must be responded to by the creditor and the credit bureau. So one of the ways you start fixing things that are in error or that are mistakes is to challenge those entries that are on your credit report. If a creditor fails to verify the disputed item within the 30-day limitation, then the entry must be removed. Failure to obtain verification is where the system falls apart to your benefit, because the creditor often views the task of having to submit updated information to the credit bureau as an inconvenience, and they usually won't do it. Further, the creditor may have not recorded the information accurately, and therefore they can't verify the entry on your credit profile. Or the account may have been closed, or it may have been on your report for more than 2 years. Most creditors, believe it or not, do not keep good records on old closed accounts or accounts that have been charged off for more than 2 years. With that in mind, it is extremely important to know that credit card debt or debts they fall under what they call in the law a statute of limitations. If a creditor is going to sue you on a debt, in most state jurisdictions, they only have 4 to 5 years to actually sue on a debt. If you have an account, whether it's a credit card, a loan, or anything that you haven't paid on for a long, long, long time, because it fell behind, you forgot about it or whatnot, and it's getting close to the statute of limitations, what you'll usually get is a phone call from a collection agency or even Internal Revenue Service and say, hey, you know what, we want to work with you to bring this credit situation to a good status, and we'll work with you to set up a payment arrangement. That is a trick. And as church people say, that is the trick of the devil. Because the reason that they're calling you is because it is getting close to the statute of limitations. And if you send in a payment, even one payment, you begin, acknowledge and verify the debt, and the statute of limitations starts all over again. You start that clock all over again, and they get another 4 years to collect the debt. So if you had a debt that's out there that you haven't paid on for years, and after 7 years, remember this negative interest can stay on your report for up to 7 years, but after 4 or to 5 years, depending on what jurisdiction you're in, after 4 years usually, they cannot sue you for that debt. They can still report it for another couple of years, or your credit report until it's challenged, but they cannot sue you for it.
So
they can never take you to court and get that money.
So John, for example, many of us have old credit cards from undergrad when we were in college, okay? Just turned 18, they tell you don't get credit cards and start wasting money on buying clothes and going out and all of those wonderful things that 18 to 24-year-olds do with new credit. And then we find that it affects us later on. So if that debt, to my understanding, is about 7 years old, so let's say you're 18 back in the 90s or even early 2000s. 7 years later, that debt is still on there, and you have yet another collection agency contacting you for a credit card that you had when you were 18, and now let's say you're 30 years old. What would be the best route to, ultimately, once the consumer pulls their credit report through Credit Karma, or if in fact they do decide to sign to write the credit bureaus for their credit report, would they then go through an itemized and really basically audit their own credit report and look at the date specifically and make the determination as to whether or not that date makes sense? Because a lot of times collection agencies, as we both know, fabricate the dates.
Yes, they do. Now, this is something, this is another trick that they'll do, which you have to be extremely careful of. This is why it's important. That's a great point. It is important to pull your credit report every year, because this is what most collection agencies do. Let's say National Account System reported a debt as delinquent 3 years ago, and you saw it on the report. The National Account System had, let's say you had something at Macy's. I use Macy's all the time because I don't like it. But let's say Macy's reported you to National Account Systems. National Account Systems now has that debt in collections. They sent you Dunning letters, you kind of ignore them. And you don't have to respond to the collection agency because, number one, you didn't sign a contract with the collection agency. Now, if they want to sign a contract with Macy's or the car dealership or whoever you have them there with, that's fine. But the consumer is under no obligation whatsoever under the law to deal with that collection agency, to make arrangements with them, to set up payments with them, to send them any money. You are under no legal obligation to do that at all. You don't even have to talk to those people if you don't want to. But most people don't know that. But getting back on point, how you would get rid of it is that, and what these guys will do, if you ignore National Account System, usually after 90 days, if there's no response to you, they'll send the debt back to the creditor. Sometimes if they bought it out, they'll keep it. If they get no response or no cooperation from you, what happens is that when it reaches the statute of limitations, National Account Systems will sell that debt again to ABC, collection agency. Because every time they sell it, they're selling it for pennies on the dollar for what they paid for it. So they want to make some money. So they'll sell it to ABC, collection agency, let's say 3 years later. When ABC collection agency gets the National Account System 3 years later, they will change the date on the credit report to a date that they received the negotiable paper to collect the debt. So now that shifted and gave them 3 more years ahead to start collecting the debt again. That's wrong. What you should have is a copy of that debt as it was originally reported with that original creditor, because after 7 years, remember, which is different from the statute of limitations to sue on the debt, they can't report it on your credit at all anymore anyway. Even though you may still owe it, morally, they can't report it anymore. That also goes for student loans, that goes for child support debt, that goes for bankruptcy. It goes for all of those big ticket items. Once it has been on your credit report for 7 years, you can send a letter in and say, hey, this item has been on my credit report. I don't care if they say today. This item was initially reported on my credit on such and such a time, and send them a copy of it and say, so therefore, I want to remove from my credit report. And even though you still may owe the debt, even though they may still be trying to collect it, they can't sue on it if it's outside of statute of limitations, but they can still attempt to collect it. But they can only do it if you make a payment arrangement or if you, God forbid, send in a payment. And then it's done. Now, I'm not telling you that you shouldn't be responsible and pay your bills. By all means, you should. But if your creditor refused to work with you and turns it over to a collection agency, then that's on the creditor. I have never paid the collection agency anything. Even if my debt got behind, once I got the money to pay it when I was living that lifestyle, you know what I would do? I would send the money to the original creditor until I got educated and learned that you can avoid situations like that altogether by simply doing this. If you know that you have a bill that's due on the 1st and it's late by the 5th of the month, and you know for a fact that you're not going to have the money, then this is the responsible thing to do and keep it from being reported negatively on your credit report. If you call up the creditor on the 29th or the 30th, and you say, look, this payment is due tomorrow or it's due, it's in 2 or 3 days, I don't have the money. And I'm not going to have it to pay it by the late date, by the 6th, okay? I don't have it. So here's when I can make a payment. Now, if you make a payment arrangement, and this especially works with credit card debt, if you make a payment arrangement and the credit card company or the merchant accepts that arrangement, they cannot report the payment as late because they just changed the terms of the payment agreement from the original contract that you signed that's called waiver. So if you call your mortgage company or your car, finance center or your credit card company or whoever it is, and you make a payment arrangement and they accept that payment arrangement, they cannot report that payment as late. That is illegal. And if they do that, it's an unfair debt collection practice. You're entitled to $1,000 per day per violation. It's a reward that you get from the courts and government for them violating the law.
Now, so that people are clear, for that particular payment, it won't be late. But for the prior payments that have been late, that could still potentially show up on your credit card. Would you encourage the listeners to, I guess the word would be not haggle, but negotiate with the collection agency or the initial creditor?
That is correct. Now, you can always negotiate your items on the credit report with the original creditor because the folks who report it may be the collection agency, but the collection agency is only going by what the original creditor reports to them. So you can call up the original creditor and negotiate deals, which I've done that in the past. And I said, look, I know it's been a while since I paid you, but I have the money now. I want to pay this account out or pay it over, or I want to negotiate, work something out with you that instead of paying you the $2,000 I owe you, if you would take $1,400, call it good, let's just wipe it out. Let's just take care of it. But in consideration of me doing that, or in consideration of me paying this off, whatever it is, you have to correct the entry on my credit report from being delinquent to paid as agreed. Now, that is a legal term because even though it may have been late, the original creditor has the authority, the power to direct that collection agency change the entry to paid as agreed, which is not negative. And or you can say, in consideration of me paying this debt off, I want you to remove your entry in the credit bureau, period. Don't report it was good. Don't report that it was bad. I just want your entire entry that I've ever done business with you to be gone. They also have the authority to do that. Now, if you call up and talk to a clerk, someone who's making like $9 or $10 an hour, they'll tell you, I can't do that. I don't think we can do that. That's why you need to talk to a manager and someone who has the authority and that has the sense or the know or the wherewithal to know that that can be done. Or call up and ask to speak to someone on their legal team that can get it done for you. Because it's very simply done. It's a keystroke and it doesn't cost them anything at all to do it.
Here's the other
incentive,
thing.
is to have you to pay the debt. So most creditors will work with you because they want to get the money. They want to clear it off their books. So, they don't really care about it being reported to the credit bureau. Although they sign contracts and agreements not to do that kind of thing, many of them will do it in order to get the payment in and to close out their books. They'll do it.
Now, here's the other thing. You have situations with creditors ultimately. So let's take a step back. This was one of the questions that have been sent regarding education loans, and we are dealing with creditors. The U.S. Department of Education can become a creditor ultimately. And in the event of, they have a program, to my understanding, where you can consolidate your loans and you re-sign an agreement and agree to have the new debt for up to 7 years reported on your credit report. If there are any potential errors with that new agreement, and I do realize you had just explained, once you sign a new agreement or make a payment, it's pretty much over. Is there any recourse for the consumer if, in fact, they did find that they made a mistake with a U.S. Department of Education 7-year agreement?
Okay, but remember that the U.S. Department of Education usually contracts their outstanding debts to be collected by other agencies. One of them is like
ACS.
It's ACF
IDAP.
or it's like an ECMC is another one. There's several third-party collection agencies that they use. Just because it's an education loan doesn't mean that those third-party collection agencies fall outside of the Fair Debt Collection Practices Act or even the Credit Reporting Act. They still fall under those guidelines and under those rules. They still fall under the same penalty. So if you have a Department of Education loan and it was inappropriately listed or docketed or tried to, they were trying to collect it and they violate your rights, you still have the same remedies under the law as you would with, national account system. It doesn't matter. One of the things with the student loans collection people, what you really need to look at the credit report is because many times when you look at your credit report and they report something as delinquent, they'll report it like 5 times on the same account. So you'll have 5 or 6 different entries, which will bring your credit score way, 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 way down because they'll put a negative entry on there 5 times for the same amount of money or the same debt, which that's not correct. It should only be 1 entry. But for every time they put it on there, it lowers your credit score by, somewhere between 25 and 60 points. So that can be really devastating. That can bring an otherwise 650 or 700, credit score down to in the 400 to 420 to 425. That doesn't make sense when they do things like that. And they do it like that out of spite. You know, the same way with the people that owe child support. Now, owing child support is a really serious issue, because the guys that are out there that are deadbeats and even women that are deadbeats that don't want to, take care of the kids, yes, they should use every means available to get you to pay for your responsibility. However, there are some men and women that have been caught up in this situation where they have paid child support, albeit for kids that are not even theirs. And the credit bureau will report that. But here's what happens with a lot of these counties and states. Once the kids turn 18 or over 16, depending on what jurisdiction you're in, and there is no longer a requirement to pay child support because the child has reached majority, 5, 10, 15, even 20 years have gone by, and the state is still reporting that you were in arrears on child support. So is that money being paid to the custodial parent, or who was that custodial parent to the child? Usually not. Usually what happens is the state will then convert that money to reimburse itself for any type of insurance or anything else, or educational benefits or opportunities it gave to the mother of those children, or even to the children themselves. But they don't list it as that, as a debt to the state now. They'll still list it as child support. And the reason that they do it as child support arrears is because child support arrears has no statute of limitations. They can try to collect that forever. And the government has its own methods of doing it. They can offset your taxes. They can capture your state tax return. They can garnish your bank account, with no trial, no hearing, no court dates, no due process, no nothing. But the state knows that if they list it as a debt that goes to the state, not only is it dischargeable in bankruptcy, which child support payments are not, but they can go after you for an indefinite period of time. Now, that's something that needs to be changed in Congress, because it's unfair to a lot of folks who no longer owe any money to a minor child or even to a custodial parent. That money is going to the state coffers because they get to keep it. But rather than to just make it a debt to the state, they will still list it on the credit report as child support arrears. And that's not right. But they do it. They do it all the time. It's a very, very common thing that happens. And what is your remedy against it? The only thing you can do is file a lawsuit against the state and the county. And what I would even do is file a lawsuit and name the individual people, like the caseworker. I would name that idiot. And I would also name whoever the prosecuting attorney is that should know better than that, because the duty of the prosecutor is to do justice. That's across the country. The duty of any prosecutor in any state or county jurisdiction or city jurisdiction is to do justice. And when they don't do the right thing, they are not doing justice. So me, John Carter, y'all know the little bastard that I am. When I sue folks like that, that's taking advantage of folks on behalf of other people, what I've done in the past is not only will I sue the county and the state, I'll sue the individuals that will also cause that emotional distress to my client. And I will put a lien on everything that they own and show them what it feels like to have all of your property encumbered with liens and encumbrances, and you can't do anything about it. Because the only person who can remove the lien is a judge under some, declaratory judgment, which isn't very easy to get, or you have to agree to allow the lien to be released so those people can go on with their lives. But I guarantee you they think twice about how they treat people the next time they go and sit in their office. And they ask for mercy, and they don't show them mercy.
Now, this is the other thing that I wanted to briefly bring up. When consumers are after they've pulled their credit report and they're contesting these things that they're finding, they are seeing, all of the inaccuracies, dates aren't matching up. After they begin to contest it, there are several options. They can contact the debt collector directly, or the original company that they had the debt with. That's what we understood from the discussion earlier. They can also contact the credit bureau directly regarding the inaccuracy for the debt, and they can also do this online. Now,
Yes.
a lot of people think that once they dispute the debt, the first time that it goes away. Would you encourage the consumer to be diligent and stay consistent in following through and following up with regards to that one dispute?
Yes, because this is how it works. The credit bureau, if you're going to make the dispute with them, and that's who you should send the dispute to, you should make it with them because they have an obligation under the law to accurately report what's wrong or what's inaccurate on the credit report. But you have to know what you're doing. You don't tell them specifically what's wrong. That's their responsibility to find that out in writing from the creditor. But under the law, every challenge that you make must be responded to. So here's how it's done. On the 1st of January, hypothetically, you'll send a challenge letter challenging an entry as incorrect to the credit bureau. On January 15th, you would send that same challenge letter again. On February 1st, you would send that same challenge letter again. So how many challenge letters have you sent? 3.
Mm-hmm.
How many responses do they have to do? 3. But here's what happens. Here's where the system breaks down. When they get the first challenge letter, they say, okay, because they also have to get something in writing from the original creditor, which usually won't have it or can't do it, that this is incorrect or it's outdated or it's stale or it's been on my credit report for more than 7 years. I want this in. 2 weeks later, when they get the second challenge, the credit bureau looks at it and says, oh, well, this must be a duplication of the first one that we did, so we'll disregard this one. And it's over. The entire entry, if they fail to respond to any one of those challenges, the entire entry must be permanently removed from your credit profile. It must be completely gone.
So let me ask you about the notice to validate the debt. In a situation where let's say the original creditor or even the debt collection agency, I've seen in situations where if you send a notice to validate the debt, oftentimes they respond, sometimes they don't. You may deal with the retaliation situation. All of a sudden you get hit with bills that you didn't expect from that creditor. With the notice to validate the debt, can you give the consumer a little insight on how that works?
Yes. Now, sometimes a creditor may send you a letter, and it usually comes from a collection agency saying that you must respond to this within 15 days or within 20 days or 21 days of receiving this letter. Otherwise, we're going to deem the debt as valid. Or they'll say, if you don't respond to this by such and such a date, and then they have a date certain in there, it's usually 2, maybe 3 weeks down the line, that we've received authorization from our clients to pursue this matter further and take legal action against you, blah, 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 blah. It's all bullcrap. Don't believe it, because the deadlines and timelines set by credit agencies or credit collection agencies are meaningless. You hear me? They are meaningless. Because on the back of that letter, when you look at the validation notice, it says that you must respond within 30 days. You have 30 days, to dispute the validity of this debt. And if you don't respond within 30 days, because you really have 30 days, but even if you take 60 days and you dispute the debt, that dispute is still valid. Mm-hmm. Now, if the letter on the face tell you have 15 days, but under federal law that you have 30 days, and any language in that letter that shortens that 30-day time is a violation. So for every letter that you get like that, or every phone call that they make, it's vitally important that you document it or keep those letters, because for every letter that you get that violates that section, that creditor owes you $1,000. It's $1,000 per day per violation. When these people call you and leave these messages on your machine or messages on your phone, you should save those, because if they're threatening to call the sheriff, to have you arrested, to sue you and all these things, it's especially, in a situation like this. Say you live in Illinois and a collection agency out of Florida sends you a letter, and in that collection letter, it threatens some type of legal action, or they're going to take the matter further. Go online, Google that agency, and see if they are licensed to practice law in Illinois. Or just simply call the Illinois State Bar and say, hey, is ABC Collection Agency licensed to practice law here in Illinois? No, well, because they just sent me a letter saying that they're threatening to sue me. Okay, ABC Collection Agency out of Florida doesn't have a law degree. First of all, it's not a law agency usually, a law office. But if they're threatening to sue you in Illinois, guess what? That's also another violation. It's $1,000. Plus, you can now send a copy of that letter to the Secretary of State for Illinois with a complaint to their, collection licensing bureau, and they will fine them as well, because you can't do that. You can't threaten to take action that you lawfully cannot take or that you don't intend to take. They can't even threaten to sue you unless they have a bona fide intent to actually do that. It just can't be an empty threat to make you pay the debt. But folks don't know that. So
That
what
is
they do,
interesting.
they get nervous and they run to the bankruptcy court or they run to the bankruptcy attorney. And I've seen people file bankruptcies that were absolutely ridiculous. I can't tell you how many clients I've saved from bankruptcy simply by asking them some questions. Well, why are you filing bankruptcy? Well, because this one particular creditor keeps calling me, just threatening to do this and do that. Okay, well, what if we can shut that creditor down? Would you be trying to file bankruptcy? Well, no. Okay, then let's go after that creditor then. So I would sue the collection agency.
Which makes a
You can
lot of
do that, you know.
sense. And to be a fly on the wall in the lunchroom of a credit collection agency during lunchtime. And I say that, again, we get back to undergrad, and one of the ways and the fastest positions that younger people are able to walk into as far as employment, believe it or not, here in Illinois, collection agencies hire many of our reentry members of society. They hire many of our members of society who are not as educated and give employment opportunities so that they can financially sustain themselves. The problem is that it doesn't seem like the collection agencies are as regulated here in Illinois.
Oh, well,
Unfortunately,
they're regulated. You know, even if they're not regulated under the state law, which they may not be, that's because the state may have reverted or they, acquiesced to the federal statutes to govern, which is better anyway than most state law. So, for those people that do have problems with the collection agency or even with the faulty credit reporting, which is uh, even more damaging to you when they don't accurately report your credit profile, you have a remedy against that. And while the state of Illinois may not go after those people and may allow those road companies to operate, it doesn't mean that you as a consumer have to tolerate that. That's the whole point of this program, tonight, is to let you know what your rights are and how to assert them. So let me just talk about some of the things that you can get off your credit report. What can be removed? Non-verifiable entries that are correct. Even if something is correctly reported on your credit as negative, but if you write those letters challenging it and they're not verified, it must be removed. Non-verifiable entries that are partially correct must be removed. For example, if there's a report that shows a write-off of $200 and the actual unpaid balance was $225, this is incorrect. It's an incorrect portion of the entry, and it will justify removing the entire entry if verification is not made. That's why you have to be smart about writing those credit bureaus to tell them what's wrong. You don't tell them, oh, well, it's wrong because instead of $200, it was actually $225, because guess what they're going to do? From the horse's mouth, you just told them how to fix it. What you do is just say it's incorrect. Now, let me tell you another big mistake that a lot of consumers make. They'll go to creditkarma.com, and as a service to them, they'll say, oh, if you find that there are entries that are not correct, you can challenge them through our system. You can do it right here online. Now who does creditkarma.com work for? Your creditors, right?
right.
So do you think doing the online challenge and fixing the credit report online is a smart idea? It may be effective. It may have some effect. But what's more effective is don't do it online. Write a letter. Put everything in writing in a letter, because a handwritten letter under federal law has much more weight than something that's typewritten or something that's done online. So what you should do is that you copy off all the information. So in your captions, you notify that credit bureau of your name, your address, your date of birth, your social security number. That's how they identify you. That's how they make your whole credit profile. So all those pieces of information are important. You tell them how long you've been at your address, and then you tell them what entry or entries that you deem are incorrect.
So as we wrap
that letter,
up,
and then every 2 weeks, for a month and a half, you send those letters out.
Keep following up. Yes. So
your credit bureau. That's how you get it removed.
As we wrap up, we want to be sure that you all have the email address if you have any questions. consumleg@gmail.com. Please contact us at 619-994-0792. John Carter. Justina Winfrey with Consumer Legal Hour, iHeartRadio, Intellectual Radio, Consumer Legal Hour. Have a blessed evening.